actually to step back a little bit and look at the various roles of the parties involved, and also, frankly, to look at experts who aren't necessarily going to be a witness for you, and then look at the possibility of where you have situations where experts who play an advisory role for you ultimately end up being a witness for you, and some of the pitfalls associated with that sort of approach to life. I'll try and keep up with my slides. Here's a basic outline of what we're going to talk about. We're going to talk about the distinction between the two types of expert roles. We're going to talk about experts serving a dual function, and then intermixed with all of that will be the essential obligations of the experts and the differences of those obligations in the different roles that you might choose them to take. Then we're going to talk a little bit about the limits on retaining counsel's role in dealing with their experts, and then we're going to essentially towards the end talk about the do's and don'ts with experts, and that is largely a shopping list of how to and how not to prepare your witnesses for cross-examination if you choose to use them as experts. I think it's essential, if we step back to the beginning of a case when you get your retainer, it is important, if not imperative, that you identify at a very early stage of the proceeding what kind of expert assistance you may require, whether that be an expert advisor to assist you in understanding the technical aspects of your case, and also recognizing that you may very well need an expert to testify at the trial. And you need to start thinking about this early, and you need to take steps to make sure that when you do retain experts, that you don't somehow, through your dealings with them, destroy their ability to facilitate or for them to be of assistance to you. And so in this regard, it's very important early on in the exercise to identify what you in fact want your expert to do. Do you want them to be sitting in there with you as the part of the litigation team, developing a theory of your case and figuring out the best angle, the best theory that you can get from A to B to your desired result? When you're looking at the kind of expert you want, you need to think about the implications of your choices. For instance, if you choose to go with an expert and you choose to stay with a single expert who provides both an advisory role and then also provides potentially an expert witness role, there are implications for doing so, and you need to be mindful of that. Oftentimes early in a case, and I'll come back to this in some of the other slides, you really need two experts. You need one in an advisory capacity to assist you, and you need, secondly, an independent expert who can then testify at your trial. I appreciate that some cases do not warrant that kind of expenditure of resources, but anything else is really a shortcut, and you're creating some problems for yourself down the road. The next two slides really sort of quickly describe the differences of the role. There's the expert advisor, and he or she is truly a member of the litigation team. Free and frank and open discussion. You can canvass all kinds of possibilities as to how best to advance your case, where your weaknesses are, where your strengths are. Their role is clearly to assist counsel. And as a result, they don't have any role or obligation in this capacity to the court or anyone else. And the beauty of this relationship is, to the extent that they stay as an advisory expert, all of their documents, all of their files, and all of the solicitor's communications with them will remain privileged and will never see the light of day, subject to some major slip-up. Then you flip over to the experts that we've mostly been talking about here today, and those are your expert witnesses. And clearly, one of the primary objectives, and I haven't put on here that they have expertise. I take that as a given. I appreciate that you can't take it necessarily as a given, and that you have to ensure that the person that you identify and retain to be an expert truly has the expertise to cover off the particular question that you want answered or you want evidence presented to the court on. With respect, so the first item is the objectivity and impartiality. The extent to which your witness can be seen to be unobjective and impartial is of paramount importance, and so it's very, very useful for you to have the ability to review their CV early on before you get too far down the engagement to make sure that there's nothing in there that would spook you or nothing in there that you can't manage going forward with respect to the case. The next bullet, it says, role is to assist the court, not be an advocate for the client. This is essentially a common law proposition. However, it's now being codified in the BC civil rules. And now, in fact, before the court, before you can tender an expert witness before the court, they have to certify that they are aware of their role and that they are aware that they are not to be an advocate for any of the parties or for its clients. What's interesting is in practice, for some reason, you appear before the Environmental Appeal Board and you'll get reports now today that have this same certification even though it's not required, and in fact that could be some useful grounds for cross-examination going forward. The primary difference between the expert advisor and the expert witness is the fact that as soon as you tender that evidence, all privilege is waived over that expert's files, that expert's communications with counsel. While people will debate this in the courts as to whether or not you can compel the lawyers to turn over their files, it happens. It is something that you need to be cognizant of, and you need to ensure that there's nothing there that you're embarrassed about, there's nothing there your witness is going to be embarrassed about going forward. I'm not going to dwell too much on the law, but I think that this is a useful case describing the differences between the two different roles, and I am going to read it, unfortunately, but here it goes. So long as the expert remains in the role of a confidential advisor, there are sound reasons for maintaining privilege over documents in his possession. Once he becomes a witness, however, his role is substantially changed. His opinions and their foundation are no longer private advice for the party who retained him. He offers his professional opinion for the assistance of the court on its search for the truth. The witness is no longer in the camp of a partisan. I'm actually going to continue on the paragraph in the case, and this is a decision of, as he then was, Mr. Justice Finch when he sat in the Supreme Court of British Columbia. And the next sentences read as follows. He testifies in an objective way to assist the court in understanding scientific, technical, or complex matters within the scope of his professional expertise. He is presented to the court as truthful, reliable, knowledgeable, and qualified. It is as though the party calling him says, here is Mr. X, an expert in an area where the court needs assistance. You can rely on his opinion. It is sound. He is prepared to stand by it. My friend can cross-examine him as he will. He won't get anywhere. The witness has nothing to hide. If you could measure your witness against those statements, you're in good stead before you head into court. And now touching on the whole dual role aspect, we say here that it's possible but difficult in execution, and I would say in the environmental sector, it is unbelievably common. We say here in the second bullet, there's a possible loss of privilege over the entirety of the expert's files once the opinion is tendered for use in evidence. There is some school of thought out there that suggests you can go and retain an expert in an advisory capacity, and you put in your retainer that he's being retained to be an advisor, and that subsequently you can then retain him under a separate retainer to give expert evidence, and that somehow that may give rise to you still being able to maintain privilege over his advisory capacity files and then waive privilege over the subsequent files. It is a very dangerous proposition indeed. It is not something that I would recommend, given that the disclosure and the waiver of privilege is broad, and this whole rationale is broad, is to ensure that there's nothing in the file that goes to the witness's credibility. So if he says something in his advisory capacity, I would argue, if my opponent attempted to do this, that we should be entitled to see his advisory files, because what clearer evidence would there be if he's changed his evidence from when he's in an advisory role to when he's sitting in the stand giving witness evidence. So I don't recommend that practice. The next bullet talks about it being commonplace but not necessarily desirable in environmental litigation for experts to serve this role. And you see it in contaminated site litigation all the time. And it's partly born out of necessity. It's also partly born out of resources and the amounts that people want to spend. What happens is you'll have a site investigated. It's a large, complicated site, and teams of experts will work on this site for years. They'll have miles and miles of information and data and detailed understanding. And then all of a sudden, you're in front of the Environmental Appeal Board. They're challenging challenging a remediation order, or you're in front of the court where there's a cost allocation piece of litigation that you're involved in. And one of these same experts who sat providing the expert assistance in dealing with the remediation is now sitting there. They've been employed by the same person on the same project for 5, 10 years, and they're giving what they say is impartial, unbiased evidence about things that go to who's responsible for the remediation of the site. It's a dangerous proposition indeed. What happens is, I'll just step back for a minute, because you can sometimes see on larger contaminated site files where parties who have control over the expert evidence that's going into the regulators to determine what needs to be done to remediate a site, you will see slowly but surely things change in subtle ways that ultimately will support a different allocation of liability to different parties than you would see in the first couple of expert reports filed. And you see, basically, without knowing it's happening, but you sure sense that it's happening, that counsel is involved in reading these things as they go through the process of putting this supposedly objective assessment of a contaminated site for the purposes of what's required for cleanup. But at the end of the day, these reports will have utility. These reports will be relied upon to allocate responsibility between the parties. So you have experts doing those sorts of things, probably at the direction or suggestion of counsel, and then ultimately these same witnesses sometimes step forward and testify at trial or testify before the Environmental Appeal Board. It happens, and we're always going to deal with this, and it comes down to a frank assessment if it's your expert, if you think that you can present your expert in such a manner that they're still seen to be objective and still seen to be reliable. The same problem, and if you're looking for case law that deals with these issues, look at construction cases, look at engineering negligence cases, because oftentimes the people that testify ultimately in those cases as experts in engineering or experts in respective construction things, they are often people that have had involvement with the client through the bit. Unfortunately, like we've heard earlier today, typically their reports are allowed in depending upon how obnoxious they are on the witness stand. But typically those reports are allowed in with it all going to wait as to what the court's going to do to it. So the next slide is more of the same. Where possible, consider 2 experts. I appreciate it can't always be done. The next bullet is this, is that things in files morph over time, roles change over time, and that's what we're calling here the mission creep, to adopt a favorite US expression. Be cautious, understand what you're doing when you then propose to use your expert advisor as an expert witness, and think about the consequences. I'm going to now shift a little bit to where experts breach their duties and what happens. And really, these are just two possible outcomes in a spectrum. I guess judging by the discussion today and judging by the propensity of the courts and the boards to admit evidence but give it little weight, I suppose he should put at the top of the page there, give the evidence little weight as the lowest in the spectrum. And then perhaps judging by the comment earlier today that below the orders for special costs, that perhaps contempt proceedings if it is really egregious and they're caught lying, or there's a finding that they were caught lying. And with respect to special costs as well, there's also a spectrum there. It can go all the way from the party having the costs awarded against them to counsel having the award against them. And I've never seen it, but I can't imagine it's not in the spectrum of the possibility where something's really egregious and perhaps even the expert should have costs awards against them. With respect to this area, there is a dearth of good case law. Well, there's a dearth of case law in any event. But with respect to the inadmissibility of reports, part of the reason I think that there's a dearth of case law is it doesn't happen very often because of the reasons we heard today. Secondly, those rulings typically are made in the course of a trial and hence don't give rise to written reasons or don't give rise, frankly, to very reasoned reasons. So there isn't very much case law. I won't go to each of these cases. Some of them are, frankly, a bit ridiculous, especially the Warkinen versus Riggs and the Turpin manufacturing. In these cases, and it's hard to judge how bad these reports were, but essentially the primary problem that the judge had with these reports is they used excessive bolding. Italics. Whoa. Anyway, strange decisions indeed, but they must have been fairly egregious for the result to be warranted. Maris versus Seymour Entertainment Ltd. It's a little bit more interesting, but not much. It's a fairly goofy situation. It would be nice if they appended these silly reports to these decisions so you could see how bad they really were. Basically, the comments by the court was that the report contained many pages of comments and summaries of various records and reports the expert reviewed, which were neither necessary nor of assistance to the jury. Okay, well, big deal. Then it gets goofier. It's not goofy. It just says that it was unclear from the report. You couldn't tell what the facts were, what the assumptions were, and where the opinions were. You couldn't segregate them out. It contained editorial comments which were unhelpful, et cetera. So it's still not a very interesting case to read. If we go to the further up the spectrum when we talk about special costs, essentially the jurisdiction is exercised to order special costs is only exercised where there's what's known as reprehensible conduct that is so egregious that the court or the tribunal wants to disassociate themselves from this kind of conduct. Again, some of these are not all that outrageous. Some of them, the first two, deal with situations in which a party tenders an expert who has been repeatedly rejected by the court in the past, and counsel has known that. That's the primary problem in the first two cases. The second case also has some other goofy things that The expert was told to absent himself from the room while the counsel and opposing party argued about what questions could be put to the expert. And the expert was caught sneaking back and poking his head into the courtroom and watching the proceedings. Again, not the most ideal situation. The decision, and this is a decision I was involved with, and so was Mr. Letcher and Andrea Akalaitis, and this is the C-SPAN ULC versus Director EMA. This is an environmental appeal board decision out of British Columbia, and this is one of these interesting places where a board exercised its jurisdiction to award costs. The board typically, or doesn't do that. None of the boards across Canada do this with any regularity. It's a rare case indeed. And what's interesting about the jurisprudence and the policy that the boards developed in British Columbia, and I believe it's followed across the country, is that they only award regular vanilla costs against a party if the conduct was reprehensible or if there are quote unquote special circumstances. So essentially, to get regular costs in front of a board, you have to establish essentially special cost circumstances. And in that case, in part, as a result of the dealings with the expert in that case, the Environmental Appeal Board issued special costs against C-SPAN in that case. Now we're going to get a little more, start getting more sort of practical. Some basics here in retaining and instructing experts, and we're now talking about witnesses. Clearly, avoid suggesting the desired outcome. Ensure that they receive a reasonably objective set of facts. And this is important. It seems mundane, but you don't want them to receive a set of facts that are on their face obviously biased. You also want them to receive a set of facts that you can ask them to assume and that you can, with some level of surety, prove in court such that the expert report has some weight given to it. The next two items, basically it says limit communications with the expert, limit counsel's role in editing the expert's opinion. Practices vary wildly in this area. We have been involved in a constitutional case in British Columbia. It's involving our French school board. It's a minority language rights case that's now gone on for over a year and has got another 6 months to go. There are experts being tendered in that file that would make your hair curl with respect. A lot of these experts are career experts for the cause of French language minority rights in Canada. There aren't any drafts of any of the reports. They're huge reports. They're unbelievable. They're massive. And the closest we could get was that there are days of meetings between the experts and counsel. No notes, no reports, but the reports were admitted in evidence. It's useful to have a discussion. There's no rule that you can't have contact with your expert during their retainer, your expert witness, and there is now no rule, or thankfully no rule, that you can't have some role in editing an expert's opinion. I actually don't think I'll read this. Actually, perhaps I will. It's fairly useful. I think it's a reasonably accurate description of an appropriate role. And again, this is Mr. Justice Finch as he then was. It says, nor do I wish to condemn the practice of counsel consulting with his expert in the pre-trial process while reports are in the course of preparation. It is, however, of the utmost importance in both the rewriting and consultation processes referred to that the expert's independence, objectivity, and integrity not be compromised. I have no doubt that in many cases these ends are achieved, and counsel and experts alike respect the essential boundaries concerning the extent to which a lawyer may properly discuss the expert's work product as it develops towards its final form. And I think the next quote is apt as well, and I think this describes and summarizes the problem succinctly. It says, the exchange of correspondence between counsel and the expert contained unfortunate language which left open the argument that counsel dictated the opinion required and the expert complied with the dictates of counsel. Counsel's editing the report left open a similar argument. Counsel should strive at all times not to place themselves in the position where their conduct becomes a focal point of the court's concern. Those are words to live by. On the next slide, there's a couple more cases cited, and they're quite useful, but of limited application. The first one deals with the situation where the court said, in highly technical matters, experts need the requirement of counsel to make sure that people can understand what their opinions say. And they said there's nothing wrong with providing that kind of assistance in drafting of the reports. The Moore versus Gedehan case, that's the case that at the lowest level, counsel was criticized significantly for editing or proposing edits to draft reports, and ultimately the court held that the report was inadmissible due to that fact. Luckily for practitioners in Ontario, that was overturned on appeal to the Ontario Court of Appeal, who basically said that in some appropriate circumstances, it is perfectly appropriate for counsel to have input into the drafts of expert reports, and they reviewed the particular changes and edits proposed by counsel in that case and felt that they were perfectly appropriate and legitimate, and that counsel nor the expert should be faulted. So we're going to now deal with essentially counsel's do's and don'ts. Again, I've talked about this earlier. Evaluate your needs for experts early. In larger cases, especially if you're dealing with catastrophic cases, you need to grab your experts and you need to grab them first. You need to team up. And sometimes what needs to happen is you need to team up, you need to have advisors right now, and you need to have people parked to be your expert witnesses. And the challenge there, in our experience, is whenever you hire experts in any of these fields, it's a brand new file, it's intriguing for them, and they want to just march off and start work right away. Well, wait a second. If you're our expert witness, we have no idea what happened here, what went wrong. We have no idea what kind of expertise we need, what kind of question we want to ask you. The last thing we need is for you to go madly off about and come up with some crazy ideas that we then have to disassociate ourselves with down the road. So you need your advisory team and you need your experts parked, okay? I guess bullet 2 is assessing the roles. We've talked about that. And then there's the whole concept of formulating the questions. And the point here is ultimately, before you put your question in writing to the expert, make sure it's what you need. And why I say that is the last thing you want is to ask some fairly innocuous open question and then realize 6 months before the trial that in fact you need a little more pointed opinion than the one you've asked for. And then ultimately you end up changing the question at the last minute, and it creates no end of grief and it creates no end of questions. And then Gary's point was very good earlier today about the particular expertise, and his example was the hydrogeologist, but the hydrogeologist not really being in a position to opine about the ecological effects of certain concentrations in the groundwater. Clearly, you need to have the expert that can answer the specific question you have. It's very worthwhile going through this exercise to think ahead to, okay, when you're going to appear before the tribunal and when you're going to appear before the court, ask yourself, how would you go about introducing this expert, and what would you say that expert's expertise was you were qualifying them for? Go through that mental exercise rather than figuring out what your expert is in the morning of the Environmental Appeal Board hearing, which I've seen on so many occasions. And then the whole next point, take steps to proactively protect privilege. That comes down to the role you want the experts to play. It also comes down to the role within your client as to, especially in complex cases with sophisticated clients, there's points of contact between your client directly and the expert. You need to structure it in such a way that that privilege is as protected as possible. That can include direct instructions, written instructions from you to your your client contacts, you to the expert. It can also include ensuring that there's a limited distribution within the client as to any work that's coming out of the expert's offices. And then I guess the next one, I keep repeating myself, keep the risk of disclosure of your files front of mind. It needs to drive, in large part, a lot of your conduct. And then, again, as Gary pointed out earlier, it should be on the list here, look at your assumptions. Make sure your set of facts that you're asking the witness to prove, or the witness to rely upon, can be proved. And then assiduously protect your expert from being disqualified or otherwise rendered unusable. We had a very unfortunate situation on one file where some eager expert delivered to us a draft report that had never been asked for. It was a horrendous thing for him to have done. He's committed himself to writing. It's like, look, we never asked for that. What's this for? So now we're faced with a situation is, can we use that expert? There wasn't even a question put to him that was formulated. And so it's a real challenge. You also need to sometimes protect your witness from himself or herself. Review his opinion. If it doesn't ring true to you, figure it out and figure out if there's something you're missing or something that they're missing or if they're overreaching. Protect your experts. And then the second bullet is, and this is where counsel clearly has a role, you sometimes get expert reports and you go, wow, that's well written, it's articulate, I understand everything perfectly. Okay, that's the exception, unfortunately, in the technical fields. People have blinders on and they're talking about C/P factors and all kinds of strange power laws and all this stuff. But at the end of the day, they need to explain it, or the overall opinion needs to be explained. Because like I say, if you can't understand it, it's unlikely a judge can understand it. So it's got to be fixed. And it can be fixed in such a way that in no way tampers with the objectivity or of their opinion. The other thing too is sometimes in technical cases where you have information flowing continuously during the retainer. Like the facts aren't fixed in time. There are drill holes being bored. There's data coming in daily. Things happen all the time where the experts really need to be able to be in a position to change their opinion if something comes up. The only thing that I would say here is if your expert changes his or her opinion when they get from their written report, when they get up to testify, make sure in direct examination you deal with it, you deal with the changes, and you deal with why they were made. If you don't, it just leaves a stench when all of a sudden it's pointed out in cross-examination that they've changed their opinion. The next point is almost always demand disclosure of your opponent's expert's files. This is curious, and sometimes counsel can be most effective if they delay requesting the files. And it used to be in our province that typically you requested disclosure while the witness was in or within cross-examination. And the beautiful thing about that is while they're in cross-examination, they can't talk to their counsel, their instructing counsel. They have no protection. So they basically deliver up this beautiful bundle of material. You then stand down the matter until the morning. You pour over the files, and you can see how the opinion is morphed over time. And an example of this, and I'm going to show my age here a little bit, when I was a first-year associate, we represented Murray Pezim. I don't know if anyone knows Murray Pezim. He's an old promoter guy, great guy, used to own the BC Lions. Anyways, he was charged in front of the Securities Commission with insider trading. And it all came down to what the results coming out of Hole 109 meant, and were they significant from a financial disclosure perspective. The investigators called a witness who was an economist. I mean, where's your first shudder with respect to an expert? Right there. Anyway, so the economist gave an opinion before the board that Hole 109 data would have materially affected the market price of the shares of Prime Resources, I think was the company. Well, we got his files, and that night we pieced through the chronology, and we could see that the investigator added the word would in his opinion. The previous draft, which was only like 2 days before it being tendered, was could. So basically, the investigator managed to get him to replace the word could with would. Well, they don't win with could. They can win with would, right? Any event. So he was confronted with this at cross-examination, and people don't think straight in cross-examination when they're confronted with things. He says, well, in my mind, they mean the same thing. Anyway, his report was not admitted into evidence. And then the other dues, and this is just read the C-SPAN decision as another due. I recommend that. It talks about issues with respect to problems that you can face in dealing with expert witnesses. I'm almost out of time here. Yeah, the next slide actually I touched on. At the 11th hour, do not change your report from could to would, or could to more probably than not, which was what was done in the C-SPAN decision. And then also, be careful about changing the question you're posing to the witness at the 11th hour as well. In fact, what can happen, or what has happened there, is you can have this fairly focused question, and then the question gets morphed into a very broad question, like they're not suggesting the outcome, and ultimately that question gets answered the same way as the first question got answered, and it misleads people to thinking that they were given a broad mandate to look at all the factors. Also, some more points. Don't ask your expert to ignore evidence. I've touched on the next two, and I won't touch the last one. So that's my presentation for today.
Do we have any questions? The computer's coming down. I think that means there's a question. Anyone else in the room while we're... So one question, what's your view on experts involved in facilities applications and related hearings? Shouldn't the environmental expert that conducted the baseline study, suggested mitigation measures, and wrote part of the assessment be the one to defend it?
Yeah, I mean, that's a unique circumstance where clearly they are the best party who is in a position to defend their work. That's not typically what I'm talking about here with respect to the dual role. I don't frankly see that as, believe it or not, as litigation. That is part of the regulatory process leading up to a decision based on the reports as tendered. Yes, put them forward. Let them answer the questions.
And the second question is, what is your view on testifying experts that are renowned in their field giving statements to media on related topics during their retainer?
Well, it's something that you hope your experts don't participate in. I mean, I've seen lawyers participate in similar things, but it's not helpful. How's that?
That's a good one. Anybody else in the room? Okay, thank you, Nicholas. So I'm going to ask Blake and Alec to come down. We went from the trenches with Jim and Terry Lee. Then we went really to black letter law to talk about why it's not impolite to object with Gary and Andrea. And now we just had some practical advice on preparing experts. But now we're going to go back into the trenches. And so what we're hoping to do now is to talk to Blake and Alec a bit about some of their experience, lessons learned, boots on the ground, experience about dealing with experts. Generally, and at this point we're talking about most of this we'll be talking about once they're on the stand and how you deal with that very difficult moment in time, either in direct or chief. So I'm just going to ask a few questions to get the ball rolling, and then we'll hear from Blake and Alec on that. I'm going to start, I think, with Blake. And then move over to Alec. Just a little bit about all we've heard this afternoon and building on all of this about the practical and difficult legal concepts around experts. Can you just give us, what are your top 3 lessons learned, or what's your experience to date to share with us and build on what we've heard this afternoon?
Yeah, absolutely. My experience with experts generally is derived from my hearing experience in the regulatory process, and that encompasses everything from the Surface Rights Board here in Alberta, including the Métis Settlements Appeal Tribunal, which is the equivalent of the Surface Rights Board on Métis settlement lands in Alberta. My experience also includes facilities hearings as well as rate hearings. So there's a fairly broad spectrum of experts that I've dealt with, but certainly if not the majority, a fair share of that has been in the environmental context. The two fundamental lessons or lessons learned that I would take away from my experience and share today. One relates specifically to the role of counsel in putting an expert forward, and one relates to the role of counsel in cross-examining an expert. In relation to putting an expert forward, obviously you want a well-qualified expert, and you want great credentials and a nice, impressive CV. But you also need to ensure that expert, that personality is going to be conducive to being an actual witness. So I think there's a very important distinction between an expert and an expert witness, and sometimes that distinction is lost when you see this glowing or fabulous CV, and it could even be a very well articulated report, which admittedly is the exception. But that doesn't necessarily mean that they're going to be a great witness. So you need to pay attention to the personality of the expert that you're putting forward. To go along with that, I think they need to be able to convey the message. So their personality encompasses their ability to convey the message, and there's probably 2 factors involved with that. The first would be their personality in general, and their confidence and their ability to carry themselves in the hearing setting. It's a fairly unique setting where you have a panel or a tribunal, triers of fact. You have a gallery of people, and you have an opposition side or opposition sides that are drilling down on you and testing what you have to say. So it takes someone. It's a unique ability to be able to function and convey your message in that environment. The other facet of that, I suppose, is I think what's already been touched on by Nicholas, and that's in taking the information that you're trying to convey and putting it forth in such a way that's understandable to the triers of fact. So you can have a highly intelligent expert up there using some fantastic acronyms and technical words and or technical terms and big words, and it's just going over everyone's head. So they need to be able to bring it down from that high level into a level or onto a level that's understandable for particularly the triers of fact. In addition to, in the same vein with their personality, I think you need an expert that's not going to be defensive. And what I mean by that is you need someone who it's a fine line between taking pride in your work and having confidence in your work and then being defensive when it's questioned. So you need someone who's able to concede points. You need someone who's able to recognize the limitations of their knowledge and of their work. There's nothing worse than seeing an expert up there who's just unwilling to concede the most insignificant or moot point, or even maybe it's a point that they should be conceding, and they just refuse to. I mean, if they're being cross-examined and it's, can you confirm for me the sky is blue? And it's, well, some people are colorblind. What's the weather? What's the time of day? That's the type of thing that's not helpful. And inevitably, what it ends up doing is turning your expert into an advocate, because it signals that they've engaged in the adversarial nature of the process, and they've chosen a side and they're pushing back towards that other side, and it's a signal to the panel and to the cross-examiner that you're essentially on the run. You've switched sides here from being an independent expert witness for the purposes of informing the panel, and now you're testifying on behalf of or in favor of the side that's put you up. In addition to the personality factors that I just mentioned, the personality of your expert may also influence how you put them forward, whether it's part of a panel of witnesses, whether it's by themselves, the order that you put them up. For instance, if they have a strong personality or a weak personality, you may want to put them up with who you deem to be your panel or witness quarterback, so that person can steal the ball back from them if they're going a little too far, or pass them the ball if they're being a little too shy with their opinions. In relation to a fundamental lesson that relates to the cross-examining of a witness, an expert witness, I think it probably goes without saying, but it bears repeating. It's simply do your research. To know the evidence or the report itself simply isn't enough. You need to have an intimate working knowledge of the actual subject matter that's being dealt with. There's nothing that derails a cross-examination quicker than asking a question that you think you know the answer to, getting a different answer, and not having the requisite knowledge to develop what that next question should be, or even to understand the answer you've gotten.
My experience is gained both as counsel, but in more later years also as somebody who sits where we're sitting right now at the front of the room and looks out at the hearing room, at the counsel and the parties and the witnesses and the spectators, because I'm a member of the Environmental Appeals Board here in Alberta, and also an ad hoc member of what's called the Public Lands Appeals Board. So as a result, in addition to gaining experience in seeing how experts and their counsel perform, I also have to give a disclaimer whenever I do something like this, which is the views that I'm going to give are in no way the views of the Environmental Appeals Board or the Public Lands Appeals Board. I guess the other disclaimer I have to give here too, because people here may forget me very quickly, but this is being broadcast and recorded for posterity. I am not a QC. Apparently, if you hold out long enough saying no, you're too busy to speak at one of these things, the Canadian Bar Association will throw in a complimentary QC just to get you here. So I do appreciate it, but I think the government of Alberta and Her Majesty the Queen kind of like to have a little bit of say in the process. So I'll have to decline the offer. But thanks for the thought, sir. I appreciate it. And my comments I'll try not to duplicate what both Nick and Blake have said, but in some ways hopefully maybe dovetail and identify or illustrate them with some examples. And again, my focus is, I started life as an insurance defense litigator and then an energy, oil and gas litigator. And when Alberta decided to enact some environmental law way back in 1993, that's kind of when I got involved in environmental law, and that's what I've been doing ever since. And a lot of that, some of it's in the courtroom, both on the civil side and on the defense side and others, but a lot of it's in the hearing room, and obviously the AB experience is in the hearing room. So you've got to, first off, clearly identify the need for expert evidence and the issues on which you're going to need it, and then do your best to get the best person in the field and get them early. So do your research, talk to people. If the people that you want to get, the expert you want to get, is conflicted out, say, all right, well, obviously you're the best because I went to you first, but who's the next best person that you? So make sure you get the best expertise you can find, and obviously the best that the client can afford. And then the other advice I'd have sort of as a going in position is to handle experts with care, both your own experts and the experts on the other side. When I started at the firm, I was articled to a lawyer by the name of Al McClarty, who's probably one of the best regulatory lawyers in the country. And I had a lot of chance to work with Al and also with a lawyer named Kem Yates, who I would also put in that same category. And you'd go to these hearings, and quite often they were utilities type of hearings. We acted for the industrial power consumers at the time. And you learn very quickly that everybody that's up there is an expert. Everybody except you. Everybody you are cross-examining is either a full-blown expert in a particular area of expertise, typically science, economics, various other things, or they're professional witnesses who go to professional witness school, so they are expert at being witnesses. So you learn very early on, and it's pretty daunting when you stand up there, because you're not cross-examining some terrified person about whether the light was red or green when they looked up and saw it in the intersection. So you know right off the bat that they know more than you do. You know that they know more than you do, and you also know that they know that you know that they know more than you do. So that can lead to some interesting situations, and you have to be prepared to deal with these, and we'll talk about those a little bit further as we get along.
So Blake, you touched on this a bit already, but just maybe to refocus, because I think this is so important from what we've heard today and just in our experience. But what are the key considerations before you put somebody on the stand? Like, other than personality, is there anything else you're thinking about whether you're going to put them there?
That's a great question, Sarah. Thank you for that.
You're welcome.
The key considerations that I note here today, they all relate mostly, I think, to the preparation of your witness and preparation for the hearing that you're about to go into itself. So, at the outset, again, I think this has been discussed a fair bit already, but you need to ensure that your expert witness is clear on the scope of their role. Obviously, they need to know what boundaries are set up ahead of time and what the expectations of them are. But also you need to ensure that any other witnesses you may have, whether they're lay witnesses, whether they're expert witnesses, are also aware of the scope and the mandate of the expert that you're putting forward. And it's important that everyone on the team is aware of each other's roles and what the limits are on those roles. The next key consideration, in my view, would be to be aware of past statements that your expert has made, whether it's in testimony, in articles or journals that have been published. Obviously, you don't want them to be saying anything that's contrary or contradictory to what they're going to be saying in the hearing. Sometimes that's unavoidable, it's already been said, but you need to know about it ahead of time so you can either call an audible or be prepared for it when the hearing comes. I'd bring that one step further too, and you need to be aware of past statements that organizations have made that your expert's a member of. And so that may be a professional organization, that may be any number of different subject matter organizations, but it also could be the employer of that expert. So, for instance, if that expert's a member of or an employee of a consultancy firm, the consultancy firm puts out issue briefs or updates on a monthly basis or something like that. You need to be aware of if one of those briefs contain one of these contradictory statements, that your expert's aware of that and has an answer for that, because inevitably they're going to come across the line of questioning where they're asked if they work for this consultancy company. They're going to say yes. They're going to be asked if they know the author of the issue brief. They're going to say yes. What are your thoughts on it? It's a colleague, so you're going to be very kind, and you're going to say, oh, he's an expert. He's very well respected. I have the utmost time and respect for him personally. And then you're going to have this issue brief put towards you, and you're going to say, well, this person who you think is, the epitome of greatness in this profession has said this. You're saying contrary to that. Can you explain that for me? So you need to be aware of those type of minds that your expert could be stepping on as they go through the hearing process. And again, sometimes it's inevitable you're going to come across things like that, but if they have an answer prepared or they've given it some thought, it makes for a much easier road. The other part of that, I guess, is past representations, and I think that's been touched on to a certain extent, so I won't dwell on that. I don't think it's necessarily as big an issue as some of the others that Alec and I would talk about, because sometimes inevitably it's just a matter of where the facts fall, and if your opinion happens to fall on one side of a certain situation, then you're inevitably only going to be testifying or acting on behalf of or representing that side of an issue. So I don't think it's as big a deal. Obviously, in the perfect world, you want to have someone that's played both sides of the field so that you can demonstrate the objective nature of what they're saying. The next key consideration I'd say is don't taint your witness, and by that I mean the hearing process, especially the prep process, can be fairly involved and fairly intensive. And you'll do mock cross, mock hearings. You'll spend days together. You'll eat meals together. You'll spend some evenings together. Lots of hours together, and what can happen is the expert will start to become part of the team and start to feel like part of the team, and you can have the most independent and impartial expert out there, but there may be a point where subconsciously they start to trend towards the team, and they want to please the team. They want to be part of the team, and their opinions and views may start to trend towards the team's views as opposed to their own independent views, and you just need to be cognizant of that. And when you're going through prep, you need to test them on everything. You can't just say, oh, but geez, wasn't expecting you to say that. That's great, glad to hear it. You need to say, why are you saying that? Can you back that up? Do your views and do your experience back that point up? Because if they don't, you're going to get into the hearing process, and they're going to be caught on it, and it's not going to be a good story for anybody. All those to say that I think prep is, if you haven't been able to tell already, prep is the most important consideration, I think. And if you're well prepped, you should come out of a hearing process. You may not win, you may not be entirely happy with the outcome, but you certainly can't question the efforts and the performances that are put forth by your witnesses. The last point I'll touch on, and it is born out of preparation, I think, is that you need to ensure your witness is properly qualified or appropriately qualified at the outset of the hearing. And that's only to say that you need to ensure that the qualification that they're given at the outset of a hearing is sufficiently broad to encompass all the subject matter that you're going to need them to talk about or that's included in their evidence.
One related question that I think tags on to what you've said a bit. Nicholas talked about how you put in, if you're going to do it in direct, if there's been a change in the opinion. And have you had that experience, and how have you handled it when you're sitting before the tribunal?
Myself?
Yeah.
I haven't come across where there's been I haven't had a scenario where there's a fundamental shift in the opinion. You certainly have, I don't think I've ever gone through a hearing where you're not making corrections at the start through direct evidence. And again, I wholeheartedly agree with Nicholas that it's imperative to do that at the outset of the hearing, so that there's no mud on anyone's face going through the hearing process. But I can't say that I've ever come across a scenario where there's a wholehearted shift or a fundamental shift in an expert's opinion.
I see Alex is nodding, so is that same experience?
Yeah, I'm just sort of thinking what would happen if that did occur during midstream, let's say when they're actually up on the stand, and how you might react as a lawyer. I don't think it would be pretty. But I can say that in proceedings that I've been involved with at the AB, it's not uncommon because of the way in which the record of the department that's been produced ahead of time, which might contain a bunch of experts' reports with respect to an application. You'll see as you get more and more information going on to the point where you end up with 10, 20, 30, 40 binders for a particular hearing, you'll see changes in the opinions that have been expressed. And the way typically that's handled, at least by the tribunal I sit on, is when it comes to setting the issues, hearing, which can be an ongoing process, that may be one of the issues that you identify up front and say, we noticed that in 2012, the consulting firm said this about the direction of groundwater flow, and yet in 2014, in their most recent submission, they're saying that that's an issue that we want to see addressed in the written submissions and at the hearing. So that's one way to deal with it. You don't always get that luxury, though, I guess.
So sticking with you, I think, moving to cross-examination, what is uppermost in your mind when you're just starting that process? Like, what are you thinking? What's your strategy? You know, just really practical advice on how you approach that.
I mean, I'm just before I get to cross, I want to I made some notes on some points that Blake made, and one, I guess, that, and I think Nick made the same point. The phrase I always use with experts is, I say you got to dumb it down. You've got to make it so that I can understand it. I don't have a science background. I have an economics degree, I guess, but don't even assume I know anything about economics. So you've got to dumb it down. And then, with all due respect to the judiciary and tribunals, I say if we're going even further along in the process, you're probably going to have to dumb it down even more. But let's at least get to the point where I can understand it. The other thing I was thinking about when Blake was talking about prior publications or associations or statements that have been made, blogs now are something that you really have to be careful with, because a lot of people, I think, wake up in the middle of the night and they're still half asleep and they have a thought and they'll blog it out there. So those sorts of things can really come back to haunt you, particularly if you're someone that's being put forward as an expert. And then they were talking about conceding, get them so that they're not so defensive, so that they can concede the obvious. And typically with experts, lawyers love to, when they're cross-examining, love to use the hypothetical question to try to get the expert, at least temporarily, to accept something that your expert is trying to say or that you're trying to put forward on behalf of your client. And you've got to prep your experts for the hypothetical questions and tell them not to fight the assumptions at the beginning. They may say, okay, for purposes of this hypothetical, can you assume that the sky is red, not blue? And the experts will just battle on the hypothetical when you want them to say, all right, if you put all that in, then I agree with what you're saying. However, your assumption that the sky is red, not blue, is faulty for the following. Your next assumption I take issue with for the following reasons. But don't convince them or get them to the point where they're because that also doesn't play well with the court or with the tribunal. In a lot of cases, you may have a tribunal that's entirely composed of experts themselves in their own different fields. And so if they think somebody in their profession or another scientist or another technical person is trying to be too cagey, that'll come out, and that derogates from the evidence. The other thing that Blake was talking about was in terms of preparation, the whole issue of whether you put your expert witnesses up with the corporate witnesses and the lay witnesses on a panel, or whether you have them sit up just by themselves to try to reinforce the fact that they are independent. They're not part of the litigation team or the corporate team. So there's different lawyers have different views on that, and a lot of it depends on the context and the forum that you're in. But when you turn to cross, the phrase that was drummed into my head very early on by one of our senior litigation partners was, keep it short and get out of Dodge. And as know what points you want to make when you go into your cross, but also put them through a sieve and say, okay, realistically, what can I expect to get from this expert? You might have 10 different things you would love to have them concede on, but if you spend a lot of time looking at their reports, talking to your own experts, realistically, you may only get them to the point that they're going to agree with you on 2 of these. Don't beat your brains out and give them a forum or a soapbox to reinforce the 8 points that you're not going to get anywhere on. And I remember I was in a trial one time, and I got to cross-examine one of the experts, and I didn't follow that advice, and I was flailing away, and it was the same senior lawyer who just reached up and tugged on my gown, and I went, yeah, and he said, get out of Dodge. That's all he said is get out of Dodge. In other words, sit down. The other thing about you use your own experts, and Nick talked about this, and you don't always have the luxury of having an expert advisor and your own independent expert witness. So quite often, your expert is fulfilling both those roles. And there's nothing wrong with them assisting you with the preparation of your cross-examination of the other expert. So, but quite often you'll find, or at least I've found, is sometimes the only they're saying, well, ask them this, ask them that. And it's really because just from a scientific perspective, they're curious about what this expert's going to say, and it's got really nothing to do with the issues in the case. And one time I was doing a hearing, and the expert wasn't sitting beside me, and he ran down the aisle and handed me this piece of paper with this question, which almost had a formula in it, if I recall, and I read it out, and which you should never do after, and the expert I was cross-examining gave an answer, and then we carried on. And on the break, I asked him, I said, why did you want me to ask that question, and why did you make such a dramatic thing about it? And he said, oh, I was just curious, because in this paper, these guys said this, and it had nothing to do with the case. So the other thing about cross is, and I always tell witnesses this when I'm preparing them, because it can be quite intimidating for a lot of witnesses if they haven't been through this before. But I'll say you always feel like you have no sense of control in the process. You feel like you're walking into this strange room where all the lawyers know each other and they're chatting away, and there's this panel up here, a judge. You feel like such an outsider. It's not your arena, and you feel like you have no control over the process. But what I tell them is, as soon as that question is asked, and it's out of the mouth of the lawyer, you are in control. You have control. You can take as long to think about that question as you want. Don't take too long, because it looks really bad if there's just silence for 5 minutes. But you're the one that's in control. So realize that, and use that to your advantage. If you don't understand the question, it's a typical sort of advice. Ask that it be rephrased. I think that's all I'll say for now. I guess the other thing is, I took a trial advocacy course years ago, and one of the instructors, it's the LISA course, it's one of the best courses you'll ever take, and a lot of people here have probably taken it. And one of the instructors that year was Serge Gajawa, who was the prosecutor of the Colin Thatcher murder trial in Saskatchewan. Very, very intimidating guy. And you would get videotaped once a day doing something, and then Serge would sit in a little room about like this, and he was a big, big guy too, and he'd sort of crowd in there, and he'd watch you do whatever it was you're doing, introducing a piece of demonstrative evidence or making an opening statement or whatever. And in my case, I was cross-examining an expert, and I called the expert, and we had a report, I called him Dr. Smith this, Dr. Smith that, or if I wasn't saying Dr. Smith, I was saying sir, and he just berated me for this. He says, don't make him look any more important than he is. Don't call him that. In fact, don't call him sir, just call him witness. Well, that's so I guess my point would be respectful of the experts. And again, you may be sitting in a tribunal where you're cross-examining an engineer in front of a panel of engineers, and they don't like to see lawyers beat up on non-lawyers. So be respectful, but don't show too much deference to the person. I was in an arbitration hearing one time, and our witness was was a financial person that was instrumental in the financing of a lot of the major petrochemical projects that were built in Alberta back in the 70s and 80s. And the lawyer that was cross-examining, very, very senior counsel. And the first thing he said after we got our guy to adopt his written evidence and did a little bit of review of his CV. As he said, Mr. Smith, you don't realize what an honor it is for me to be able to question you today in this proceeding. And you are without a doubt the dean of this and he's going on, and it's just getting so oily. Even the arbitrators who were all former judges were just kind of going like this. And finally our witness just said, please just cut it out and get to the, I know you're here to cut me to shreds. So just start with that, and let's not deal with any more soft soap.
Blake, do you have anything else to add on that?
I think the only, I just reiterate, I think what Alec was saying is there's specific reasons that you cross-examine, and in my view, it's one of two. It's to test the validity and credibility of the evidence, or it's to further a point that you're making. And if you're asking questions for any other reason, they're probably questions you shouldn't be making and certainly don't need to be asking.
So moving on, since we've got you here, are there any examples of slip-ups that you've seen? Again, it kind of goes to lessons learned, but more in cross-examination, I'm thinking, or in direct if you want. But looking at, some examples of slip-ups and how you either addressed that or how others addressed it, or if they couldn't be addressed.
Yeah, I'll try to touch on some that I'm not entirely sure can be addressed. First and foremost, it's whenever an expert enters into the realm of advocacy, that should be avoided at all costs, and it can be advocacy of one of the parties, it could be advocacy of a cause, it could be advocacy of methodology, or it could be advocacy of their work in general if they're just too defensive. Again, when an expert goes into that realm of being an advocate, it's really encompassing of all of their evidence. You can have errors in calculations, you can have errors in the assumptions you've made, and generally speaking, those types of errors, there are situations where they're all encompassing too, but generally speaking, those types of errors, they impact certain siloed portions of your evidence. They're not going to be all encompassing and wipe out the entirety of your evidence. But once an expert enters into the realm of advocacy, that's where it taints the entirety of what they're saying, the entirety of the report, and that's really hard to recover from. Another point I'll raise that goes towards a slip up that's pretty hard to recover from is when you allow your expert to start interpreting the evidence, and interpreting the law, and that can be as a result of them simply seeking to do that. And maybe they think they have a good enough understanding to do that, or maybe they're being coaxed into it through cross-examination. Whatever the situation, you should avoid that at all costs. Any expert evidence, or not any, but in a lot of situations, expert evidence or reports are going to be framed in the legal context. So there may be a legal element to their evidence, but that legal element should come through the instructions of counsel. It shouldn't be determined or framed by that expert. Once the expert starts giving their opinion in interpreting the law, they've entered a realm that they're not qualified to enter. And the implication is that their work or their report or the evidence that they're tendering is then either entirely based or influenced by an opinion or a view that they have that is not a view or opinion they're qualified to have. And again, the result of that is undermining the entirety of their evidence, or whatever portion of it is based on that interpretation. Another example of a slip-up is a example that I recently encountered, and it had to do with a hearing I was in actually just this past fall, I think it was, and there was a compensation component to it, and what the other side had done is kind of halved it in half and had two separate experts working one on each half, but what came out in cross-examination is that neither expert was aware of the other, let alone the work they were doing, and then what came out further in cross is that their interpretation of their half had kind of melded together, and there was overlap in the compensation that they were seeking, and again just entirely undermined all the work they had done, and what would have saved that or what would have alleviated that problem is simple communication of the roles and scopes of work that those experts were to do and communication between the two of them. The final point I'll raise is this is another personal practice point, and it relates to a hearing that I had in Edmonton a number of years ago, and we had traveled up the day before the hearing. We stopped and had lunch at the Earls on White Mud and Gateway in Edmonton, and car was parked in the parking lot in front of the Earls, and we came out from lunch, and the back window on the truck was knocked out, and we thought we had just hit the key and the window had come down or something. But when we got close, we realized that the window was gone. It had been smashed out, and in addition to the window being gone, so was our expert's evidence, and it had been included in his bags, and all his bags were taken. And so we had to adjourn the hearing because our expert no longer had his evidence. And I guess the takeaway from there is secure your expert's evidence or avoid the Earls on White Mud and Gateway. So.
Now that I know Alec is not a QC, I know he must have had some slip-ups, so.
Yeah, but we've only got a few more minutes. If you told me that could be the topic, I could have adjusted accordingly and talked about nothing else. I want to talk about, or pick up on Blake's point about communication between experts in this case, but years ago, we represented a client in an inquiry that the Alberta government had held into what would be needed to develop a renewable power industry. This tells you how long I've been doing this. And we represented two industry associations who had common interests in this. And we had, each one was run by a fellow whose first name was Hans. I think one guy was originally from Holland and the other guy was originally from Austria. And we had some other experts and some other witnesses. So all told, I think when we were going to put our panel up, we maybe had 5 or 6 people. And we could never get one of them to attend choir practice, as we call it, when you're taking people through mock cross examinations and all those things. And he was always out of the country or doing different things, so he never ever came to choir practice. So we get to the hearing, and one of them, I can't remember which one, is sitting over here, and the other one's sitting over there, and the other witnesses are in between, and they're being cross-examined by Council for Utilities and various other organizations, and the one would sort of answer the question, and then they would ask the other guy, and he'd give a completely different sort of policy answer. And it was just chaos. And we were sitting there, and there was nothing you could do. And a friend of mine who was a junior lawyer for a firm that was representing one of the utilities was at one of the tables behind me, and he taps me on the shoulder, and he hands me this piece of paper, which I still have somewhere in my desk drawer, and it said, "The right hands doesn't know what the left hands is doing." So that's, even if their names aren't Hans, just make sure that you're all, that's why they call it choir practice. You want to make sure everybody's singing from the same song sheet. So you don't need any solos there. It just doesn't work. Another thing I was thinking about in terms of where things can go sideways or a slip up is if you have a script, you got to prepare, you got to have a plan for cross, but there's a tendency, especially early on, and especially if you've tumbled to the fact that they know that you know that they know more than you don't, you kind of have this thing, and it's your roadmap, and it's there, and it's the only thing that's keeping you going. But you can become a slave to that, and I think it's been touched on earlier that if he says yes, then here this works. If he says yes, then this works, and it all is going to go according to plan. What happens if they say no? Or what happens if they say, and it's one of these really technical questions that you've had your expert help you formulate, and they say, "I don't understand the question," or could you rephrase that? And I remember a couple times having to say, God, I was hoping you wouldn't say that. And then turn to my expert and say, okay, what do I mean? But there's this danger, and there used to be a very good lawyer and a very good expert who always appeared as a tandem together at every single regulatory hearing for decades, I think. And the lawyer would take the stand in his order of cross-examination, or take over the podium. Expert would be sitting beside him, ask the question, get the answer, ask the question, get the answer, ask the question. And quite often the answer, he'd say, well, would you agree with me, sir, that blah, blah, blah? And the expert would go, no. And then he'd say, well, and then he'd just go to his next question, and everybody in the room would be going, well, he said, and then he'd finish all the questions, and they'd say, thanks very much, and they'd get up and walk to the back. And you'd think, okay, when they finally read the transcript that night or the day before arguments due, they got nothing out of it. So you've got to be able to adapt, and whether it's and be able to respond on your feet. And quite often, and I'm not saying experts do this intentionally, but they will try to trip you up by asking you to rephrase or saying, what do you mean by that, or does that assume the following? So you need to be able to anticipate that. And again, it goes to preparation. The other area where I've one of the many areas where I've slipped up over the years is what I call the motor mouth expert, which is somebody who you just say, good morning, sir, and boom, off they go. And you haven't even asked them a question yet. And you read the transcript, and 8 pages later, they're still going. So, and literally, I've been in ones where there was an 8-page answer that was given. And in a courtroom, a judge is much more likely to intervene or allow you as counsel to intervene and say, well, sir, I'm going to stop you right now because you're going off into an area that's got nothing to do with my question. I'll bring you back. If your counsel wants to ask you that somehow and redirect, and they can get it in, they'll do it. But I'm not interested in that area. So sorry, I just thought my phone was ringing, and I was going to say the other cardinal rule was turn your phone off. Now I've completely lost my train of thought. What was I talking about?
I don't know where you were transitioning to.
Oh, the motor mouth. All right. So, tribunals don't like it when you appear to be beating up on a witness, even though they deserve to be beaten severely, because they're not answering your question at all. So, so you're kind of stuck, and you kind of have to let them go on until they eventually run out of breath or collapse or whatever, and then you try to take them back and get to the point you were trying to make. And I was in a hearing years ago, and it was actually one of my partners was acting for another company, and whose interests were obviously aligned with the company I was acting for, so we represented two different parties in the same proceeding. And he was cross-examining this professional witness ahead of me who went on and on and on. And my partner did the old classic thing where he sat down, because he was standing up to do his cross. He sat down in his chair, and then he kind of closed his binder. This guy's still talking, like, and he sort of turned his back like this, so he's looking out into the audience. He's turned his back on the witness, and the guy's still going and going and going. And eventually, he stops. And then my partner gets back in and completes his cross-examination. So I'm the next one to go. So I get up, and the first thing I say is, well, Mr. Smith, before I start my questions of you, is there anything else you'd like to get off your chest? And he goes, well, yeah, actually, and he starts going. And I said, no, stop. I was kidding. That was a joke. I'm sort of hoping that you're going to listen to the questions and answer only the questions that are asked of you. So I guess the lesson I learned was if you have a motor mouth, don't give them an opportunity to be a motor mouth again. The other thing that came up, I think, in one of the questions that was asked this afternoon was whether an expert who misconducts themselves, I can't remember the term that was being used, in the course of a proceeding would be subject to an order in contempt. And I think the answer was likely not, given the sort of typical things that experts would go outside of. But where they can be brought to task in the appropriate circumstances is through their professional associations. And that's not all that uncommon where that will happen. And I was in a hearing years ago where I was sitting on the panel, and chair of the panel was a scientist and questioned the expert witness very skillfully, and it was obvious that this expert was offering opinions in areas that he was in no way qualified to express them, and was misinterpreting evidence and all that sort of thing. And I only learned much later that because just like we as lawyers have an obligation to report people to the Law Society if it's conduct unbecoming, this fellow felt he had an obligation as a fellow professional to do that, and did that. And that was investigated, and there was a hearing and all that. So experts, they're not completely at liberty to do what they want because they're stepping into our world. They've still got their own professional ethical obligations under their associations. Now, the last thing I'm going to offer just really is more advice. There's always the feeling that the experts that you are cross-examining are so wise, and they're much wiser than you. So, and Blake and I have proved this over the years. Not that we're not wise, but the best way to counter that is grow a beard, because it allows you to do this when you're cross-examined. It makes you look very wise. Otherwise, you're just playing with your face, which looks kind of weird. So that's my only. Yeah.
That's a very helpful lesson.
Right.
That last one.
And use sunscreen. I guess we do that.
And use sunscreen. So we have, I can't see that far back, but I think we're about 2 minutes. Is there one where it's been a long afternoon, so I know everybody's been very good, but does anybody have a question before we head to our next panel? Nope. Thank you so much. That was great.
Please join us.
You're gonna make
Excellent.
them wow me at the end of the day.
Oh, hey, this is great. Yes. No, that's
You got it right? Yeah.
Okay, our final session then is on continuity of evidence and remediation advice for investigators. John and John, take it away.
Thanks, Alan. I'm John Cliff, and I'm going to open with the same provisos, or whatever civil litigators call them. We're speaking our own personal opinions and not necessarily reflective of the firm that I'm with or the Government of Canada, for which John Clark is counsel to. I'll open first because that's what the agenda says. I'm going to address the issue of continuity of evidence. And just say this, that this is one of those topics that is grist for the mill for what we've been hearing about experts. And it's also an area that's got to be developed either at the trial or at an administrative hearing, to be, if you're going to go that route, that is challenging analyses as a result of the way evidence was gathered and kept and stored, part of the so-called foundation or assumption evidence. So we have written a paper. We've taken two unrelated topics and blended them into a paper dealt with separately, and we commend it to you. My topic is narrow, it's focused, and at an end of a beautiful day out there, it's probably going to be a little bit boring, but I'll try to keep it as interesting as I can. I'm not going to be referring to my paper. It's there to be read. I'll just say this, that continuity as a legal concept and as applied during a trial or a hearing is itself evidence. Continuity of evidence is what is termed many times as chain of custody evidence, or chain of custody evidence, and essentially pertains to how physical evidence that's gathered, received, or seized during an investigation is handled, cared for, stored, and preserved prior to a trial or hearing so that the trier of fact or the decision maker can be assured and satisfied that that evidence is identifiable and authentic. Some examples. Is the evidence the same as was gathered, received, or seized during the investigation? If source of the evidence is relevant, that the evidence came from that same source. The evidence has not been tampered with in any way. And finally, if chemical composition of the evidence is relevant, that the evidence has not been any way altered, modified, or changed, contaminated prior to its forensic analysis. So the onus of proof of continuity is on the party, obviously, that's tendering that evidence. There are consequences if continuity is not established. It's more likely that the trier of fact or the decision maker will attach little or no weight to the evidence. It may very well be admissible, but it's a question of weight. The most drastic, of course, is that it's found to be inadmissible. With respect to in the environmental context, let me just say this, that it's particularly relevant, in my view, that is chain of custody evidence or continuity evidence. And in my view, that is essentially because of the physical and chemical sensitivity of much of the evidence that is either seized, gathered, or received during the course of that investigation. And the classic examples, of course, are samples of suspected pollutants, samples of impacted aquatic environment, impacted flora and fauna. All can change from the time it's gathered and seized, and has to be, and as a result, has to be cared for prior to its forensic consideration. Now, continuity evidence is most relevant to whether the later forensic analysis of that evidence is reliable. And I'll just pause and add a little bit of an anecdote, because as a prosecutor in this area for a number of years, there was always that question I could ask of the analyst and those that gathered this kind of evidence, particularly as it relates to suspect pollutants. And that is, well, if the investigator didn't put it in this certain container, or if the investigator didn't keep it at a certain temperature, what would that effect be? And I never had a case where they said it was ruined or somehow didn't have any weight. Most times it came back from the experts, oh, that would mean that it would just be, in fact, less toxic than it had originally been. So you've got to kind of think this out a little bit. It doesn't necessarily mean don't back off from your case because they didn't follow procedures. Seek out that additional opinion from the technical person. Generally speaking, I would say this, that a case, an environmental case, whether it's before the court or before an administrative tribunal, should never, there's no excuse why evidence from such a case should be lost for the sake of a break in continuity. That should not be happening. And I say that because most government environmental protection agencies today have internal procedures, internal policies with respect to how to deal with this type of sensitive evidence. Most times these technical folks are trained in the gathering this evidence, trained in how to handle it and store it and transport it. Now, there are exceptions, but I do say that essentially what you're talking about is either, and I hate to be blunt, that the investigator, the technician is lazy, or there's some kind of human error. Now, what is evidence of continuity at trial or in front of an administrative tribunal? In its simple form, and the hope of the party tendering that evidence is that the other side is going to admit it. That's the easy way out. There's an admission. If there are no admissions, and this happened to me many, many times, where everything is an issue in that criminal prosecution for pollution, that it's full out, prove it. And it is normally, and I would suggest always, it's viva voce testimony of a number of witnesses that are testifying about the sampling containers, the lids they used, the markings they placed on the sample containers, the labels they placed, the storage that the samples were put under, the transportation of those items, and so on until they get to the forensic laboratory for analyses. It is tedious and it is boring evidence for the trier of fact or the decision maker. On occasion, it has to be presented. And I'll pause with an example. In a case I prosecuted many, many years ago, everything was an issue in the case, but for the date that the incident happened. And we had to prove that. And it meant, in this particular case, the case was the matter of Regina versus the Commissioner of the Northwest Territories. An incident happened in Iqaluit. The offices of Environment Canada were in Yellowknife, and the laboratory was in Edmonton. So you can imagine, when they had an investigation conducted on Baffin Island, samples had to be transported to Yellowknife, they had to be stored in Yellowknife, dealt with in Yellowknife, and the focus of my example is driven from the refrigerator in the Yellowknife office of Environment Canada to the Yellowknife airport. That Environment Canada employee, at the time of the trial, worked and lived in Halifax. He had to come back. There was no admissions. Had to come back that he took those containers, put them in the back of a pickup truck, drove them to the airport, and gave them the Canadian North to be flown to Edmonton. That's how technical that got with respect to chain of continuity. So I say that I do commend to you in my paper, if you want a feel, for those of you that have not had to deal with issues of continuity, I cited and quoted from it, of all people, and I didn't realize this, Interpol has published a manual on pollution investigations. It is well written, it's plain English, and it describes the detail with respect to conduct of chain of continuity. I do have one further example I want to throw out, and it's from the drug side. And that was my background. I was a drug prosecutor and moved into the regulatory field, and in particular environmental prosecutions, before I left the Crown to go back to private practice. And one of the cases I prosecuted near the end was a lengthy jury trial. And one of the issues was the continuity of 1,000-kilogram bricks of cocaine. The defense wouldn't admit the analyses, and we had to prove how that cocaine found on a beach in northern Vancouver Island got to the laboratory. And it was quite a process, 3 days before a jury to prove continuity. So, pushed into it. You've got to be prepared to prove it. And I say pushed into it, it may very well be. I'm talking it from the Crown perspective. And John, I hope I'm not using it too much time here, and you've got time. Pushed into it, even in the civil side. You've got samples that have been taken of the impacted environment. It's got to be proven. There's not going to be any concessions from the other side. You've got to be prepared to lead that evidence. And in that vein, you've got to sit down with those that took the samples. You've got to sit down with those that received the samples and appreciate the process that those samples were dealt with. You're going to have to call witnesses to present that evidence. One suggestion I would make would be, as best you can, lead those witnesses until there is objection. Honestly, don't go to, you never lead a witness and so on and so forth. I would start off leading until there is an objection. And for example, in the drug case I made mention to you, you do get a trier of fact or a decision maker saying, do we really have to hear that the sample got into a container that was rinsed out 3 times, was sealed, was taped, affixed? Do we really have to hear this, counsel for the other side? Now, that said, if you are counsel for the other side, and your experts have briefed you that this is significant, don't back down, don't be pushed by the trier of fact. You have an argument to make, ultimately, at the end of the day. You need evidence for that. So I do say it takes preparation, and from the other side, many times, they're looking for a slip. And I'll end it with that. Thank you very much. John?
Thanks, John. No, in fact, you asked about the time. John Cliff and I have given at least 50 different talks about environmental enforcement or environmental litigation. We have always gone over time, and I think we're going to break a record today. So it is Friday afternoon, so that was great. And so yeah, you're probably wondering how you get to give the last talk on a long day at the end of a long week. So I'm pretty sure it was because the organizers noticed that my topic was very upbeat and would leave everyone with a feel-good sense. So I'll do my best to oblige them on that. I think that's why I did it. It wasn't because you were incommunicado for the last month and a half.
Thanks, John.
The topic I want to speak about, as John said, we sort of tried to blend them together. These are sort of more of the in the trenches suggestions. But how do you deal with the issue of remediation or cleanup when you've got an active environmental investigation? And we tend to be focused on the investigation, the court process. Lots of investigators and experts are like that as well. So that's the topic we want to focus on. There is another side to this. John did give the normal disclaimer as well. These views expressed are my own, not Canada's or the Department of Justice necessarily. But I do want to also acknowledge that Todd Gerhardt, a couple of prosecutors, Todd Gerhardt and Jim McCauley from the Federal Crown and Provincial Crown did really provide some helpful comments and feedback on them, and I wanted to acknowledge them because they both promised they'd be on the internet. So thanks, Todd. Thanks, Jim. So yeah, how does the topic arrive? I think it arrived perhaps most in one of the most obvious ways in a course John and I were giving a workshop on environmental enforcement in Calgary. And it arose, there was a couple of fishery officers had to come and investigate something that came from Hay River because there was no other fishery officers in the prairies. And a rancher close to Calgary, or reasonably close to Calgary, had decided he didn't like the location of a stream and had moved it about a kilometer down his property line. And so these guys, it was a lot of effort to come down and investigate this. And in the course of it, we've talked about experts a lot. And of course, they needed an expert to go out on site and confirm the value of the stream and the effects of moving it. And in the course of that, the expert actually happened to be, he was a very nice guy. He was recently from private practice, recently from an environmental consulting firm. And apparently, according to the owner, he had implied that if you could move that stream back, that kilometer back, things would go well. And so when the investigators came, and they went up to Aaron Ehard's office. I'm not sure if they, I know they went several times to your office. They were obviously intent on prosecuting this case, and several of us, including John and I and others, had to explain that it would be an abusive process at that point to go forward, given the evidence. So what we always took from that, or certainly the advice we always gave from that, was what you say can have legal consequences. It doesn't mean you shouldn't say anything or do anything. It means that you should, as a lawyer or as an investigator or as an expert, be aware of the consequences of the effects of what you say. We certainly didn't want people not to say anything. So some of the reasons why we want to address this topic, and probably the first is obvious. It's always been our assumption, and I think it's shared by many, that cleanup and remediation is always in the best interest of the Crown. It's always in the best interest of the public. It's always in the best interest of the accused. And so we want to allow them to make that happen. I think an investigator, I remember, put that much more succinctly when we were giving some details about the investigation. He said, I would rather be the guy on the Exxon Valdez that manages to turn it away from the rocks than the guy who gets the most compelling hydrocarbon samples. That was I think a perspective a lot of people have when they go on site, and we were dealing with a lot of people who are going on site. So some of the reasons why you want to make people aware of those issues, from a legal perspective, the Crown never wants to be seen as getting in the way of remediation. An investigation, no matter how enthusiastic investigators or experts are, it's clearly not helpful for your case if it is shown or it appears that their efforts hampered cleanup or somehow made the offense worse or the effects more persistent. So people have to be aware of that and take efforts to make sure they're not seen to be doing that. And by the way, that's not hard when John, usually the collection of time-sensitive evidence can be done, pictures and samples and measurements and identifying individuals. You can do that by clearly showing you're not getting in the way of anything. We've had more than one occasion accused saying, or potential accused saying, I would have cleaned up, but for no one asked me. And it sounds sort of silly when you say it here almost, but you can imagine the circumstances of not particularly, I know you all represent, many of you represent very large corporations, but smaller corporations or individuals, all of a sudden their site is inundated with uniformed people, someone's taking photographs and samples. They may be confused about what they can do and what they can't do, and it's much better for the Crown or the regulator to be clear about what's a good advice. Another reaction I've had, and other comments that I've had from investigators or experts is they have a perhaps naive assumption of what courts can do, the value of a court order, the benefits of a court order, how effective that will be. And I paused to note, we talked about creative sentencing a bit this morning, and John and I have been involved in dozens of creative sentencing going back 25 years and are strong proponents of pushing the limits of what a court can do to make remediation orders or put funds into places where cleanup will take place. But none of that has nearly the scope that negotiations or discussions between a well-informed regulator and a willing owner or corporation can do in terms of cleanup. So sometimes you have to explain that to regulators. As well, a part of that is timing. Again, all lawyers here, but probably only lawyers appreciate just how long it is between something happening and the most straightforward incident actually finding itself in front of a trier of fact. So lots of environmental incidents really benefit from more speedy efforts. I know Gary is still here, Gary Letcher, and we had an interesting file years ago where in the course of constructing a bridge in the area of Vancouver, there was hundreds and hundreds of tons of fill were placed on the water side of some dikes and on some quite sensitive vegetation. So it was in winter, and the water levels were low, but it's an area that where water levels would rise and freshet would come. And I think an order might have been granted, either an order was given or direction was given to his client, and Gary, being the very competent and also very careful counsel. I remember in conversations with him, it was very apparent he made it very apparent to me that his client was absolutely in no way culpable for this. But the order was given to, the direction was taken by him, and he went away and dealt. He never made it clear to us how he was dealing with it. Again, he certainly made it clear to me or implied that his client didn't pay for anything, but hundreds of dump truck loads of material were removed well before freshet, and so the much more significant effects never took place, and I believe charges never resulted in. So there's some real significant benefits that can be achieved by both counsel and investigators in the course of an investigation. How are we doing for time here? Again, as John said, we have prepared a paper, and I'm just going to highlight some of the points from the paper. And I think one of the important things for investigators is often to help them before or in the very initial stages in terms of what the context or the background of a specific case. So I think lots of people here represent very sophisticated clients, and there are lots of cases, and we have been involved in lots of cases where there is a tremendous amount of expertise and mandate to clean up and deal with environmental incidents without any recourse to regulators, and that's done without. And in those circumstances, it's easy enough for regulators and others to determine that. And in those cases, remediation never has to be an issue in the investigation. As well, this is really getting into the trenches. There are some sites that and some incidents where really they can't be remediated, or certainly not quickly, and certainly not with the folks at hand. And there really is just the potential to make matters worse. And certainly none of us like to be involved in investigation of cases where it appears that advice or direction from regulators has only, in fact, worsened the problem. So recognizing those sites and the limit of your own expertise is important. Again, if we're dealing with accused that are not as sophisticated as perhaps some of the ones that we've raised here, been talking about today, it's important to recognize that as regulators or lawyers or others, who you're dealing with. Often, or in many cases, it is the lack of sophistication or expertise or care of the accused that's actually led to the incident in the first place, and that may not be the person that you want dealing with delicate environmental remediation. Again, I think a case John and I dealt with or a question we dealt with was talking to a couple of inspectors after it was a case where a landowner had removed hundreds of meters of riparian vegetation, and as happens, the stream was the stream bank was rapidly eroding into the river, and a common treatment for that is to spread hay bales and hay over this, and it tends to slow down the erosion, and that was the advice that they provided. But the landowner didn't appreciate it was the kind of hay bale you give to your horse. Kind of hay bales he had were 8 feet in diameter, and that's what he placed on the edge of this bank. A couple of them went into the river, washed down. There was a bridge with a couple of very large culverts that got plugged, and the questions we had to deal with were potential liability for a bridge being blown out. So, knowing sort of the limitations of everyone is always a very good idea. So, I guess my final point, and the point I think most prosecutors always wanted to make was being clear, making sure that you're as clear, and your regulators and lawyers are as clear as they can about what the Crown's position is. As I said, clearly you want to be clear that you're not getting in the way of remediation efforts of the accused. But document the advice that you give. In our age, it's easy enough to confirm by email the advice that you gave on site, and that can be very relevant later. I've dealt with many regulators who really have very good advice, lots of expertise. They really can be of assistance to to accuse, especially where accused don't have a lot of expertise themselves. And you don't want to hide that expertise under a rock. Some fishery officers have a practice of drafting quite extensive cleanup letters, and the letters are explicit and say, that the advice here doesn't hold out the hope of avoiding prosecution, and they don't hold out the threat of prosecution, but it's a way to fully explain and document the good advice that the Crown might have. And I guess just extending that one further step, and I know the speaker this morning talked about different kinds of orders and or directions. And a lot of environmental legislation has the ability for regulators or other people appointed to give orders to people. And certainly in appropriate circumstances, I think there are environmental and legal benefits to providing that explicit legal direction to people. I think where parties comply with it, as I think was the case with Gary's, it's clearly, as prosecutors would say, it all goes to sentence, if nothing else. It all puts the accused in the best light, and may well lead to no further charges, no further steps being taken by the Crown. Conversely, if steps aren't taken, if the accused ignores the directions, obviously that can form the potential for other charges. And as probably many of you know, those sorts of charges for failure to comply with the direction are far easier to prove, given, as I think the first speaker was mentioning, if you can show that the order was reasonable and was delivered, due diligence probably ceases to be a factor. I think that's exactly takes up our time, and I really want to appreciate everybody staying around for our talk at the end of the day on Friday.
Absolutely.
Are there any questions? Yes.
We're not sure where the best pub is, but we're hoping to learn that really soon. So that's
I'll start with that there.
I'm curious if you have seen these differences.
I'm having some trouble with your handwriting.
So my question is, often there's a difference between regulatory prosecutions and criminal prosecutions in terms of standards that are set out by Defense Counsel. And I'm just wondering, from your experience, when you're dealing with continuity of evidence,
Yes.
if you felt that there's a higher standard placed on Defense Counsel looking to establish some reasonable grounds that there's a problem with that exhibit as compared to a criminal prosecution.
And can you repeat the question, please?
I'm hoping I can repeat your question. You're asking whether the obligation on defense counsel to show some kind of effect, I'm going to reword it a little bit, of the break in continuity is different in a regulatory context versus a criminal prosecution context? Is that essentially your question? Yeah, I didn't, let me just go back for a moment. In my paper, I do make the distinction. For the sake of my oral presentation, I did not. Continuity of evidence, strictly speaking, or chain of custody, is something that's normally associated with enforcement actions being taken. It's not to say that it's not relevant in a, if I can call it a non, or a civil or administrative context, depending upon what is being sampled and for what purpose it is being sampled and what reliance is going to be placed on the forensic analyses. So I go back to that point and say this, that there's an expression that is used in many environmental protection agencies when they're doing the sampling, and that is it a legal sample? Meaning, is it something that is going to be relevant to an enforcement action or subsequently to a prosecution, where continuity has to be carefully documented and established, versus what is termed non-legal, that is for compliance purposes only. And the only thing I could suggest about answering this question is really gonna be dependent upon what is the purpose of those samples? What ultimately is the reliance going to be on the results of those samples? Is it gonna be so necessary for whatever presentation purposes you're gonna make of that evidence that you have to ensure that this is carefully sampled, carefully transported, and carefully stored so that there is an accurate authenticity going with those results? I don't know whether that answers the question or not. And I don't know.
Well, I guess what I'm thinking of is, often when we're applying charter issues to regulatory prosecutions, so say a prosecution has issued a fact,
Yes?